Today's video, we're going to be speaking about the criminal burden of proof, or what the burden is for the government to prove someone's guilt in a criminal case. In any contested matter, whether it's a divorce case or a family case, a custody case, a personal injury case, a civil lawsuit, or a criminal case, one party has the burden of proof. And what that means is that party is responsible for showing something to the judge or to the jury or an administrative panel. And if they're able to reach that burden of proof, if they're able to prove their case to that extent, then they can prevail. So today we're going to dive right into what those different burdens are and explain them as they apply to a criminal case in the end. So first off, we have the amount of no evidence. In the case there's no evidence, nobody's reached their burden of proof. But how that's most applicable is in traffic stops or involuntary or non-voluntary forced contacts with law enforcement. So if you were stopped driving down the road and the officer had no valid basis for that stop, you weren't speeding, you didn't run the stop sign, you didn't have a broken taillight or a taillight that wasn't operated properly, you weren't swerving in between lane lines for allegations of a DUI offense. If there's no evidence for your stop, then that is an illegal traffic stop. If there's no basis for law enforcement to stop you on the street, then that's an illegal stop and your rights have been violated. And if that's the case, the government has no evidence, and then that stop by itself is illegal, and what happens after that should be prohibited. So we're going to start with the level of no evidence. So if there's no evidence, a traffic stop will be invalid even for speeding. If there's no evidence, then you cannot be arrested or detained without your will. And if there's no evidence, it can't even give rise to the low level required for a Terry stop, which we'll speak to in a minute. So the next level is reasonable suspicion. Reasonable suspicion is a low burden of proof to determine whether a brief investigative stop is appropriate. So in the case of Terry, the Supreme Court decided that in a circumstance where something just doesn't seem right, if someone was pacing back and forth in front of a storefront multiple times at an unusual time of day, or had weapons, or someone's in a high crime area and they're doing conduct that's concerning, that might give rise to that reasonable suspicion for law enforcement to want to interact with that person, try to find out what's going on. Now that would be a seizure of that person by stopping them from their normal going, but it's a very minimal intrusion, and the courts have decided that with a reasonable suspicion, law enforcement has the right to stop you, to speak to you, to identify who you are, and try and find out if something beyond just the everyday ordinary activities going on. But that is not sufficient to prove your guilt. In a criminal case, it is sufficient for law enforcement to speak with you. So reasonable suspicion is insufficient to prove your guilt in a criminal case. The next burden we come to is probable cause. This is probably a term that you've heard over and over again, whether it's Law and Order or cops or any type of legal show that you may watch in the evenings for fun or entertainment. If you've seen movies about cops and robbers and lawyers and litigation, you've probably heard of probable cause. And what probable cause is whether a search or arrest is reasonable. So if law enforcement has a valid basis for a traffic stop and they have a probable cause basis to stop you, to detain you at that site, if they have reasonable evidence to support probable cause, then there may be grounds for an arrest. There may be grounds for a search. However, that is not sufficient to prove your guilt in a criminal trial. However, probable cause is sufficient evidence in order for someone to be arrested, and there are circumstances where a warrant may not be required if there's an exigency or some reason that in that moment the courts have said that if these circumstances are present, a warrant is not needed due to the exigency or the emergent situation, but probable cause is still necessary for that arrest or that stop. So probable cause as well is insufficient to prove your guilt in a criminal trial in any jurisdiction in the United States. The next level to come to is preponderance of the evidence. If you're a Denny Crane fan, if you used to watch any courtroom dramas or anything concerning civil law, civil litigation, preponderance of the evidence is probably something you've heard time and time again. And what preponderance of the evidence means is must be more likely than not. They have to get to that 51%. So if I present my story, if you present your story, and the judge or the jury believes just a little bit more than my case is supported, then that's a preponderance of the evidence. And whether it be a family court proceeding, custody trial, divorce, division of assets, or dispute as to real property, if one party can show by the preponderance of the evidence that their case should prevail, then a civil proceeding they could be successful. So, for instance, in a personal injury case, if you had to go to jury trial to seek damages for your injury or your property damages, if you were able to prove to the jury that your claims were valid, that you had met your burden as the plaintiff in that case by a preponderance of the evidence, then you could prevail, you would win the case, and you would have met your burden of proof as a plaintiff. But that doesn't apply in criminal settings in any jurisdiction. So again, if the government can prove by a preponderance of the evidence your guilt, they have not reached their burden and you cannot be found guilty. So the next burden of proof that's common in the United States is the clear and convincing standard. And that's slightly higher than the preponderance of evidence standard. It's used in some administrative courts that have a higher burden, something greater is at stake than some of these issues we've spoken about as to a family case. One of the most common examples that we give is a DHS case. So in order for DHS to take your custody against your will, say deprived action or something to remove your children from your care, your custody, DHS has to show by clear and convincing evidence, which is a substantially high standard, well beyond the 51% of preponderance. They must show much more than that to prove a clear and convincing level of evidence, their burden of proof, that your children should be taken away. And that applies in some other settings, but that's the most common one that we speak to. So if the government can prove by clear and convincing evidence your guilt, they have still not met their burden and you should be found not guilty. Next, we have the idea of reasonable doubt. And that really strikes at the core or the initial issues as it relates to the burden on the government in a criminal case. Now, if there's a reasonable doubt as to your guilt, if there's a reasonable doubt as to the government having met one of any of the required elements for a crime you're charged with, if there's a reasonable doubt as to whether you, in fact, are the person that's identified in the case, if there's a reasonable doubt as to whether or not you receive consent in a crime that requires a lack of consent, if there's a reasonable doubt in the case, you cannot be found guilty in a court of law in the United States, whether that's the state of Oklahoma, whether it's any other jurisdiction or venue. So if there's a reasonable doubt in your criminal case, then you will be found not guilty. And it's important that you hire a criminal defense attorney if you're facing a criminal matter who will hold the government to their burden that if there's a reasonable doubt, you'll be found not guilty. And last and certainly not least is the highest burden that exists in American jurisprudence, and that is that of beyond a reasonable doubt. And that is the burden that applies in federal criminal trials if you're indicted for a federal crime in any of the federal districts. That is the burden of proof that applies in district courts in any state across the United States, specifically all district courts for felonies or misdemeanor offenses in the state of Oklahoma. That's the burden of proof that even applies in military cases. So if we're representing somebody in a court-martial action, the trial counsel for the government must prove our service members' guilt beyond a reasonable doubt to a panel of service members, of senior officers, in order for our client or a person to be found guilty in a criminal setting. So, if the government is able to disprove every reasonable doubt against you, if they can show that everything that your defense attorney raised, every issue that you brought to light, every credibility claim that you brought forth, every lack of proof or lack of evidence for any element of a crime charged, if the government, the prosecution, can disprove every reasonable doubt in the case, then the government can meet their burden. So, if the government is able to surpass any reasonable doubt, if the government is able to show beyond a reasonable doubt your guilt, then that is the only circumstance in our American justice system that the government can prove your guilt and that you can be convicted by a jury. Unrelated to the burden of proof, but an important thing to keep in mind is that our justice system requires a unanimous jury in criminal proceedings. So not only must the government must have evidence, the government must go beyond reasonable suspicion, must go beyond probable cause. Preponderance of evidence doesn't apply civil case. Clear and convincing evidence doesn't apply civil case. If there's a reasonable doubt, you should be found not guilty. But if the government can prove beyond a reasonable doubt that you are guilty of the crime or crimes charged, they must also prove that to a unanimous jury. So if you can test the charges in your criminal case and the government is able to prove beyond a reasonable doubt to every single juror to unanimously find your guilt, then you can in fact be found guilty in your case. Now, this is just one issue to keep in mind. There are many things that go on during the proceedings of a criminal case. It's important that you speak to your criminal defense attorney, that you ask questions and understand all the steps in the process, understand each of these burdens, what they mean, how they apply, because some of them do relate to a criminal case for suppression issues, law enforcement issues. But again, the government cannot prove your guilt, cannot have you be held accountable for your case unless they can prove your guilt beyond a reasonable doubt.